Welcome to Signed and Settled, our plain English guide to UK settlement agreements. Today, a first-time client sits down with our legal team to find out exactly what these agreements are and how they work. My employer has just handed me something called a settlement agreement, and honestly, I haven't a clue what it means. Is this something I should be worried about? There's no need to worry. A settlement agreement is simply a legally binding contract between you and your employer. Usually, you agree not to bring certain claims against them, and in return, they give you something, most often a payment. So, in essence, a settlement agreement is a formal deal, a clean, agreed ending to a dispute or an employment relationship with terms both sides accept. Speaking as a manager, employers offer these because we want certainty. A settlement agreement gives both sides a clean break, without months of dispute hanging over anyone. That's right, and it's important to know an offer isn't an accusation. Employers often use settlement agreements in redundancies or restructures simply to tie everything up neatly for everyone. For the employer, it's about avoiding the cost and uncertainty of a tribunal. For the employee, it can mean a quicker, more generous exit than the alternative. Now, here's the crucial part. A settlement agreement is only valid if it meets strict legal conditions. These come from the Employment Rights Act, and without them, the waiver of claims simply doesn't count. The first rule is simple. The agreement must be in writing. A handshake or a verbal promise is never enough to make it binding. And critically, you must receive independent legal advice on the terms and their effect from a qualified advisor like a solicitor who has insurance covering that advice. Employers typically contribute towards the cost of that advice, so do ask. So, to be binding, the agreement must be written, name the specific claims being settled, and confirm you've had advice from an insured, qualified advisor. Okay, that all makes sense, but what exactly am I giving up if I sign this thing? Typically, you'd waive the right to bring employment claims, things like unfair dismissal, discrimination, or claims over unpaid wages and redundancy pay. That's precisely why the law insists you get advice before signing. Here's what a typical waiver covers: the employment claims you agree not to pursue once the agreement is signed. But remember, you can't sign everything away. Accrued pension rights are protected, and personal injury claims you don't yet know about are usually carved out too. So there you have it. A settlement agreement is a formal, written deal that only binds you if you've had proper independent advice. Never sign in a rush, get advice, understand the terms, and we'll see you in the next episode.